Morning. Please be seated. This is the time set for oral argument in Mesa versus Granville. Our cause number 1CA SA150303. Counsels, I'm sure you're aware we have read the briefs, conferenced the case, and are quite familiar with the issues in the case, so you can bear that in mind as you begin your presentations. I should advise you that I believe today's proceedings are being videotaped and will be posted to the court's YouTube channel if you want to watch the argument afterwards. And to that end, if each of you would announce your appearance and that of the party when you represent when you approach the podium, we'd appreciate it. Each side will have 20 minutes for argument. The petitioner may reserve as much time for rebuttal as you wish, but you're responsible, of course, for watching your own clock. And with that, we can begin.
Thank you. May it please the court and counsel, I am Eric Kessler. I am the lead attorney in the capital case of State versus Mesa. With me is Second Chair Sandra Hamilton. I would like to reserve about 5 minutes for that, for the rebuttal. I appreciate Your Honor having advised us that you're pretty familiar, the bench is familiar with the facts of the case. I know that I have filed many pages of pleadings both in the state and the appellate court on this matter, and I certainly don't want to simply go over those. There are some gray areas or areas that I think I wanted to fill in with a little bit more substance that they were not dealt with in the briefs, maybe as much as I would have liked. First and foremost, what Judge Granville did, and what the state has done in part, is to conflate the two arguments that we offered in support of our motion to strike. Number one, we argued the constitutional rulemaking authority of the Arizona Supreme Court and how you read the rules, the various rules of construction, how you try to discern the court's intent, and how you enforce those rules. That's on the one side. On the other is the due process claim, and that involves, as you know, a showing of prejudice in most cases. In Judge Granville's minute entry ruling, and I'm quoting, he said, even if a NOI or notice of intent is deemed not to reset the clock, defendant has not shown prejudice, which suggests to me that Judge Granville was failed to discern that there were two separate arguments being made.
Mr. Kessler,
yes.
Before you, and this may be related to your argument, but from a factual standpoint, I'd like your take on what differences you perceive between the two cases factually, if any.
Between Godoy or?
Between the two indictments.
Oh, factually. Well, with respect to the capital eligible offense, there is no difference. It is the same offense, same victim.
But was there newly discovered information?
There was.
And what was that?
During the course of the first prosecution, well after the rule 15.1I1, which I'll just refer to as the rule, well after that time had run, the state engaged in a free talk as such with defendant, I'll call him Lorenzo. He was the other defendant who was not noticed for death. Based upon the information the state gleaned from that, the state felt that maybe they wanted to change their mind and pursue the death penalty against Mr. Mesa. They felt that Mr. Mesa's involvement, his culpability was greater than what they had originally envisioned. And as a result of that, and keep in mind the amount of time that passed, 6 months after that free talk, defendant Lorenzo entered into a plea agreement with the state, a cooperation agreement. 7 weeks after that, the state re-indicted Mr. Mesa and added 2 additional non-capital charges. One was conspiracy to commit first-degree murder. The other was first-degree burglary. They also added a defendant Erica Vasquez. And it wasn't until 3 weeks after that re-indictment that the state sought to dismiss the old case, the first case.
And maybe we're jumping the gun here, but how was your client prejudiced by having those simultaneous or those 2 indictments pending at the same time?
I'm not saying that he was necessarily prejudiced by having 2 indictments pending at the same time. He was prejudiced by being re-indicted in a different case.
How was he prejudiced?
Pardon me?
How was he prejudiced?
Well, had the state, upon learning of the information that it believed supported a death penalty for Mr. Mesa, had the state then sought a supervening indictment to add the 2 new charges, which are not capital eligible, the state would have been precluded under the rule to file a notice of intent.
Right. Obviously, he's prejudiced by the fact that now he's facing a possible capital punishment. But how was he prejudiced because of the delay? In other words, in essence, as I understand it, your argument is you shouldn't be able to, state should not be able to re-indict after the time period file the notice of intent is run, re-indict and start the clock running again. And the question I'm having in this case, by doing that, how was he prejudiced? I mean, did he lose witnesses? Did he lose evidence?
I understand. Well, to be clear, it is our position that he need not show prejudice. Okay. But what I would do is refer the court to State versus Holmberg. Now, Holmberg was decided, I believe, in 1996 or 97, well before the 2009 amendment. And in that case, the state waited some 15 months from the time of indictment to file the notice of intent. And it was shortly before trial. What the trial court did was say, well, that's okay because we're going to continue the trial out a sufficient amount of time to allow you to prepare your mitigation case. And Holmberg, the court in Holmberg, the Arizona Supreme Court said no. And specifically, this is the position that they took. If the court will indulge me, I'll read a couple small quotes. Although the court reset the matter to March 3rd, which was a 5-month extension, by then the damage had been done. The parties had been engaged in extensive discovery. No mention had been made of the death penalty. Defense counsel had no reason to develop evidence that would mitigate a death penalty, no reason to obtain co-counsel, and in today's world, a mitigation specialist, until it was too late. The filing of the notice to seek death cannot be a 15-month afterthought. This completely eviscerates the purpose sought to be achieved by the rule. Mind you, that is a rule that has less teeth in it for purposes of getting the mitigation started than the 2009 amendment. The parties, the lawyers, the court, and all others must know that it is a death case from the outset. And most importantly, the court in Holmberg said if a substantial violation of the notice rule right through the end of the process could be cured simply by a trial continuance, then the purposes sought to be achieved by the rule would be frustrated. The prejudice to the defendant and to the system would be apparent. And the court went on to say this is not a case of presumed prejudice, but actual prejudice to the defendant and the administration of justice. The view that the court in Holmberg took, somewhat prophetic, because the Supreme Court shortly thereafter adopted rules that really embodied this point of view, was a retrospective view as opposed to prospective. I know that the state is arguing, and Judge Granville indicated that, hey, trial's 18 months away. You got plenty of time. But that's a prospective view. That's not what Holmberg said, the Supreme Court in Holmberg. They're looking at what could have happened during that month and didn't. If you look at our case, the facts are almost identical. We had a crime committed April 29th of 2014, for which Mr. Mesa was arraigned April 21 of 2014. The deadline under the rule was 7/20 of 14. At that point in time, no capital team had been assembled. There was no reason to suspect the case would go to a death penalty. I was the only attorney assigned. I didn't have a mitigation specialist. We were preparing the case for a non-capital trial. Discovery was ongoing. That's the same as in Holmberg. Then we have an indictment in the new case, April 24, 2015, 1 year after the crime.
What was the new evidence in Holmberg?
There wasn't new evidence that I can recall.
And that's my concern. Is it your position that when the state discovers new evidence that changes the nature of the charge, that it is forever barred from filing an NOI?
Yes, under the language of the current rule.
So if the facts, as they appear to the state, for example, on day one, indicate that a victim died instantaneously, and facts later emerge to suggest something quite different from that, the state's just out of luck.
Well, yes, but in the context of Holmberg, there's dicta in Holmberg that talks about that. That's because in Holmberg it was simply an oversight by a newly assigned prosecutor, or a prosecutor that was not familiar with capital litigation. And the court in Holmberg said, well, this isn't a case such that the state came upon new evidence that would support a death penalty, which would suggest that their holding might have been different. But Holmberg was under the old rule. Under the new rule, let's assume that this was not a reindictment and subsequent dismissal as it was. Let's just say that this is one long case. If the state came upon information that warranted a death penalty after their rule time had expired for the notice of intent, the only way that the state could be permitted to seek the death penalty would be to violate the terms of the rule as amended in 2009, which required primarily the defendant's consent. To allow the state to bring that notice after the expiration of the Rule 15.1 time would require the court to give no meaning to the Supreme Court's statement that the defendant must consent to any extension.
But you're asking us to give no meaning to the dictum in Holmberg that newly discovered evidence might have made a difference.
Yes, I am, and I don't say that lightly, because Holmberg was decided under a rule that was in effect at the time that said if the state believes that it wants to seek or file a late notice, in the rule itself, it was 15.1G at the time, the rule said that the state can apply to the court for leave to file a late notice, and that would be a basis for doing so. But the Supreme Court took that out in the 2009 amendment, and we have to give meaning to the Supreme Court's actions in doing that, and instead inserted any extension must be with the consent of the defendant. If we are to give meaning to those words, then any late notice absent the defendant's consent is barred. That's the plain meaning of that rule.
So your argument is, in essence, the Supreme Court came up, an amended rule, came up with a per se rule. The per se rule was if the defendant does not consent after the 60 days have run, the state, no matter what the evidence is, no matter what the facts are, the state is barred.
That is correct.
Which would encourage, let's assume in a hypothetical, assuming there are two co-defendants, several, more than one defendant, from all of them not having free talks, not willing to discuss anything, not possibly do anything on state's evidence until the 60 days have run. And then on the 61st day saying, well, we can have a free talk, I'll give you more information, I'll enter into a plea deal, knowing the state was barred from ever filing a notice of intent. Is that right?
Sure, that might happen.
Wouldn't your reading also encourage the state to file as many NOIs as possible?
Well, Judge, the Holmberg case dealt with that directly. And if
but
you
the
don't,
Holmberg case, there's a critical difference between the Holmberg case and this case. The difference between an oversight and newly discovered evidence is not trivial.
well, it may not be trivial, but it is no longer the test. Because if the trial court allows a state to file a late notice without the defendant's consent, then the trial court is violating the plain meaning of the rule.
Well, and I don't want to belabor the point because I know you're running short on time, but the Supreme Court issued Holmberg before it amended the rule.
Yes.
And so when we ask about your interpretation of this rule, I'm not sure that Holmberg is the best support. This rule you're suggesting would make it highly advisable for the state to file every single NOI it could, because it could always withdraw it later.
Okay.
But I can't imagine that was actually the Supreme Court's intent.
Well, in Holmberg, give me just a moment, Judge. In Holmberg, the court categorically rejected that argument. In Holmberg, the court said we expect our elected county attorneys to comply with Ethical Rule 3.6. And if you've got a case within 60 days per death, you file it. If you don't file it. But the state raised that argument, Judge.
Well, the ethical restrictions are a safety net that operate in a different stratum, I think, than prosecutorial discretion. And if the state is to exercise restraint and file notices only when it feels the evidence has reached a certain point, not when it suspects that the evidence may reach a certain point, doesn't it make sense to take the dictum in Holmberg more seriously?
I'm not sure I understand the question.
Well, a prosecutor could have a good faith belief that the evidence will ripen into a death-appropriate case. and file an NOI. Or a prosecutor could say, I have that good faith belief, but I don't have the evidence yet. I'm not gonna make this a death case until I absolutely have to. Which is more consistent with the intent of the rule?
Well, the intent of the rule is, I believe, to put the parties on notice with the date certain. If you look at the comment to the rule, the comment says, any extension is for the benefit of the defendant, so that the defendant can raise or try to develop mitigation in order to convince, in this case, the Capital Review Committee from issuing a death notice. But Holmberg took on the question of, aren't we going to encourage the county attorney to file on more cases than they otherwise would, and then as the evidence develops, withdraw them. And again, if you read Holmberg categorically rejected that argument. Again, citing the prosecutor's duties to be an administrator of justice. And I am out of time.
Thank you.
Thank you.
Good morning. May it please the Court, my name is Karen Kemper. I represent the real party and interest, the state of Arizona. And with me at council table is Mitchell Eisenberg. This Court has clearly identified the crux of the situation here. And where the state differs vehemently with the petitioner is that what is the purpose of the rule? The purpose of the rule is to give meaningful notice. And as this Court identified, should the state have its hands tied if a set of facts develops in a way that couldn't have been anticipated at the very beginning? And the best example that I can give this Court would be, this was a case of an invasion at a smoke shop. Let's imagine on that same day, the same number of persons, and they each go to a convenience store. One set of individuals goes to a store that has 360-degree surround, video, audio, everything. And the other people go to sort of an old-timey store that doesn't have that. Now, on day one, the state would know what happened in our ultra-sophisticated convenience store. But the state would not know on day one what happened in the place that didn't have all of that surveillance. So then the question becomes, should those individuals now be treated differently simply because a rule is being read to be strict liability, where that cannot possibly be the intent of the rule? Because Rule 1.2 tells us that these rules are to be read to protect individual rights and to preserve public safety. When you read through all the rules together, you see phrases that speak of a court's discretion. The phrase good cause, the phrase consider the impact, interests of justice, new information, materially impacted. These are all phrases of discretion.
But they don't appear in this rule.
They don't. And the state's view is simply this, that taking something away from a rule was simply because there was surplusage. Rule 15.7 did not lose its vitality. Rule 15.7 says that it applies to all of 15.1. 15.1I1 is part of 15.1. And so all the sanctions there are still intact. And the trial court thought about that. The trial court was very clear in having a reasonable extension of Godoy versus Hantman and finding that a new indictment sets the clock running anew. But the court didn't stop there. And it said, even if you do not find that the new indictment sets the clock running anew, where is the prejudice? And when my colleague read from the ruling of the trial court, there was one word omitted, and that word was undue, unfair. The trial court identified where's the unfairness here? Because simply a violation of a rule is not the same as the constitutional right that it's designed to protect. So just not complying with a rule doesn't automatically give the defendant the key to whether the death penalty will be sought or not.
Is it the state's position here that it complied with the rule? Or that noncompliance is acceptable in these circumstances?
The state's position is that it complied with Rule 15 in that it seasonably disclosed as soon as it knew of the new information. And much has been made about that timeline. But again, one of the teachings from Holmberg is that the decision to seek death must be a thoughtful, considerate decision. So just having a free talk was not enough for the state. That wasn't the quantum that we needed to feel comfortable going forward. What we needed was more. We needed to know, could this be corroborated? Was there a weakness in this story? So it takes time. And that evolved here, and then we acted as quickly as we could.
Where are the facts in the record about, where is it in the record about what facts you needed to develop after the free talk, or that did develop after the free talk? Where is that in the appendices?
I would admit to you that that's an error of not having put that in.
Was it presented to the trial court?
It was, I believe, and the trial lawyer is sitting here. I do believe that that was explained to the trial court. The trial court was very familiar with this case, completely conversant with the facts and the evolution of the case. And I think also, as a practical matter, Judge Kessler, that there was an understanding that when free talks are given, we don't immediately just throw our hands up and say, oh, then that must be the truth. We must act on that immediately.
I understand that. I'm just asking you the details of what was developed. Because it does seem to me that one way of viewing 15.1I is to say, we want, lawyers do well with deadlines. If you give a lawyer and say, you can do this anytime you want, they will take all the time they want. If you say you have to do something within 60 days, they will do their best to meet that deadline.
And some lawyers.
Some lawyers. Good lawyers. Good lawyers will meet that deadline. And so it could be read as saying, the Supreme Court was saying, we want this 60-day deadline to be written in stone so that state knows they better do everything they can to decide whether they're going to file a notice of intent within 60 days of the indictment.
Certainly, I agree with you that nothing concentrates the mind like a deadline, and certainly this morning is an example of that. But what we have to balance here is where information comes to light. And in thinking about this, it's well to remember that the state has an ongoing duty to learn under the United States Supreme Court case of Kiles versus Whitley. And that duty to learn doesn't mean just to learn some things. It doesn't mean just to learn exculpatory information, although that is our duty. But if we learn inculpatory information, where it becomes clear to us that treating all persons the same is no longer the proper course, then it becomes incumbent upon the state, in consultation with the next of kin, and with all the considerations that come to bear in that decision, to move forward in a careful, thoughtful manner. I hope that answered your question.
Yes.
So the information then that led to the change in this case was what?
So the information that led to the change in this case, and if I may have permission to speak a bit outside the record. So during the free talk, there was information learned as to, and this is why the conspiracy charge is then later lodged against the defendant, is that this wasn't just an opportunistic set of actions, that there had been discussion and agreement that they would enter the store knowing that one of them was armed, and that there could be force used to obtain money or other goods as they did. So there was that element of thoughtful planning. And then what we also learned was how the victim died, that the victim pled for his life, that he referenced that he had children, and then was murdered. So these facts lent themselves to the especially heinous, cruel, or depraved aspect. Certainly the pecuniary gain was there. So that added considerably to our understanding of what happened, because again, I return to the idea that in the modern sophisticated convenience store, you wouldn't have known all that. You would have known much of it, and we didn't. But we started to learn. And then as we spoke to other people, the other woman who was mentioned here, a co-defendant, Erica Vasquez, she confirmed that there had been some bragging by the defendant, Jesse Mesa, about the murder of the convenience store clerk, and that there had been discussion. So these are extremely important facts that had to be considered. I think this court touched on something earlier that I want to mention briefly here, when it said, well, then what would prevent the state, if it's seen as a strict liability rule, to simply file notice of intent in every case?
I
Well,
didn't quite say every case.
well,
but
sorry, of course not. But every first-degree murder case that had at least one aggravating factor. And we know the answer to that. Yavapai County tried it, and State versus White says that's not a violation of equal protection, because there will be sufficient individualized considerations by the sentencing court. So, construing that Rule 15.1 I1 as a strict liability statute, simply as a strict liability rule, simply because language was omitted from it, is inconsistent with the rules as a whole, inconsistent with rule construction, and would unnecessarily hamper the state from serving the people of the state of Arizona in a proper and considerate fashion.
Is there ever a due process concern then, based on the timing of the discovery of this information?
Certainly. There absolutely could be a due process concern about that. Because if due process truly means meaningful notice, then certainly I don't believe that the state would argue that 18 days before trial is meaningful notice. Not in the least. So there could well be situations where if the state learns something just too late, then the state could be subject to a due process violation.
But you want us to say that, at least in this case, 11 months is not too late?
The state would ask this court to decline jurisdiction, as this case, in many ways, is a very specific to this case situation. But absent a decline of jurisdiction, to uphold what the trial court did, because it was not manifestly unreasonable, and it wasn't based on untenable reasons or a misunderstanding of the law. Reasonable extension of Godoy versus Hantman, and certainly an acknowledged awareness of prejudice, and was there any? And there hadn't been. And there has not been a showing of prejudice. Petitioner continues to assert that prejudice is not required here, but the state maintains that it is. Where is the prejudice? None has been shown. Unless there are any other questions.
Thank you.
Thank you.
Yeah. Mr. Kessler, even though you ran out of time, we did allow the state to comment on some things that were outside the papers, and I think it only fair to give you a couple of minutes to address that and any questions the panel may have.
Thank you. Counsel commented about the Avapai case in response to the question about, is this going to cause other courts to, or I'm sorry, other county attorneys to sort of shoot first and ask.
Well, before you go there, is there anything about the state's discussion of the evidence outside of the special action papers we had that you care to comment on?
I am not disputing what Defendant Lorenzo said, and I believe that the state accurately represented what he said.
Okay.
Was that all you wanted me to comment on?
Well, it's wide open, but,
Okay.
but that was a concern I had. If you wanted to voice any opposition, I wanted to give you the
Well,
chance.
the other issue that was raised was Rule 15.7, and whether it still encompasses Rule 15.1I1 as a form of, or sort of the vehicle for sanctions. The state did not raise that issue in its special action response. It did raise that issue in its state court pleadings. But I would suggest that a closer look at Rule 15.7 would suggest that that deals, first off, that rule has changed. The prior version of that rule said 15.7 sanctions could be imposed where a party has failed to comply with any provisions of this rule. But after 2009 amendment, when the Supreme Court removed the subpart to 15.1I1 that said, hey, look to Rule 15.7 as your vehicle for sanctions, the Supreme Court removed that. Up until then, it was there. They also modified Rule 15.7 to say if a party fails to make a disclosure, and I mentioned in my brief, there's a difference between notice and disclosure. And the removal of that subpart to 15.1I means something. The Supreme Court meant something by doing that. Likewise, the Supreme Court meant something when it said it changed 15.7 to any violation of this rule to any disclosure. And we don't view giving a notice disclosure. A notice means you're going to tell somebody what you're going to do. Disclosure is disclosure of evidence.
Thank you very much.
Thank you. Thank you for the opportunity.
Thank you to both counsel for very helpful arguments. The matter is now under advisement. We'll issue a written decision in due course, and we'll stand in recess to allow the next case to set up.